That's great. Thanks, David. Wow, what a slot to hear from a lawyer right at the end. Brilliant. Hope you all had your cups of coffee at the break. I'm going to hopefully make this useful and interesting. Not sure about entertaining, but I'll give it a go. What I'm going to cover is just a quick trot through what bits of the law are actually relevant when you're talking about apps, and what bits of law do you need to be thinking about, whether you're a developer or a company looking to use apps as a tool in your business. Talk briefly about a case study which is based on a real set of events. Come away from that and just look at some of the key questions relating to intellectual property in particular, choice of platform and how that affects your thoughts on legals, the forms of engagement between client, company looking to use an app, the developer and the distributor, and why that's relevant in terms of your thought process from day one. And also coming back to the case study and looking at how you manage these risks effectively. And I've built in some subliminal advertising through my slides, so see if you can spot them. What are the relevant laws? There's quite a lot of legals wrapped up in an app. In fact, in relation to any kind of software development, there's a lot. There are a lot of contracts kicking about between the various parties, not least of which ultimately with the consumer of the app. And if you're looking to reach an audience or a market, the considerations about how you're reaching that market and the kind of relationship you're developing legally with your customers is key to that. Intellectual property is very important because you can't touch apps. It's all to do with intellectual property and the rights in the underlying engineering and in the content itself. Data protection is very topical just now. Really interested to see that slide with the whole range of information that someone is putting in. There's a lot of that. There's a lot of data gathered or can be gathered through apps. And it's very topical at the moment, the extent to which data protection legislation intervenes in what your obligations are as a business towards the people whose data you're collecting and controlling the use of the data that you collect. Consumer law ultimately is relevant because people tend to be acting as consumers, i.e. not for the purposes of their business when they're downloading an app. And the consumer law implies a whole load of protections for people that you need to be aware of. And there is some aspect of competition law that's relevant, particularly recently in the States. There's been a lot of furore about the App Store and access to that platform and whether it's being exercised in an entirely fair way by Apple. So the case study, this is based on a real project that we were involved in. The names have been changed, first of all, to protect the innocent and also to kind of fit the Highland cultural mix. So it concerned, if you will, an imaginary very famous footballer, and started off with someone who had an idea concerning a way to use this to access a market, and who had done a deal with the footballer and with the footballer's club to attain a range of rights relating to the footballer for exploitation. And the plan for the project was, here was our client who was the investor. They were going to set up a company. The guy with the idea was going to put in the rights he had acquired. Our man was going to put in a chunk of money. And they were going to engage, sorry about the picture, a developer, access the store, and ultimately monetize the rights that had been acquired from the footballer. So a fairly kind of, not an unusual kind of story. And I'll come back at the end to tell you what happened in that particular instance. Subliminal advertising. So when we talk about intellectual property in apps, what are we actually talking about? There's a whole bundle of intellectual property rights. Some of them hard rights that you need to go and register. Some of them just crop up by virtue of the creative process. And there are some registered rights that might be relevant. Potentially some inventive aspects of functionality might be patentable in some parts of the world. Things like trademarks, which are, can be distinctive names or logos, but also things like slogans and images, sounds and smells. And I'm looking forward to the Smell-O-Vision app. But those things are potentially registrable. But really, the main thing we're talking about is copyright. And copyright doesn't involve registration. It just arises by virtue of someone's creative effort. And that can cover the coding. It can cover content of all kinds. So images, photographs, artwork, sounds, text, music, all of those things are capable of protection by copyright. And also there are some unregistered trademark rights that are to do with reputation and brand. So all of these aspects are wrapped up. And a legal analysis of what the rights are is probably going to be slightly different to the view that you take on looking at, say, an aspect of brand that you're licensing. You might look at it as being a single whole, whereas I might look at it as being a bit of a registered trademark and some copyright and some artwork and some other aspects as well. So it's important to pick up and identify what all those different elements are. There are some other things as well, like database rights, which protect the investment that's put into putting together a complex database, although typically not the underlying structure of the database itself, and things like trade secrets or confidential information. So there's a whole bundle of rights potentially. Key questions that need to be asked in relation to any app is what IP is there? And it requires a kind of analysis. So you need to look at, yes, the structure, and yes, the underlying coding in the software. But really, content is often king when it comes to rights. And it's really important to have an understanding of what different bits of rights there are, because it only takes one to screw up the app. If there's one key bit of the picture that you've not acquired in terms of rights, that can be enough to preclude you from exploiting this opportunity by exploiting the app. And you've got to remember, particularly the developer who's got the direct relationship with the platform operator. Platform operators push all the liability, the legal liability, up the chain of development. So it's part of any due diligence process. You need to be aware of the risk there. It's often not clear who owns the IP, and this is particularly important in any collaborative venture. And development of an app is always going to be some form of collaborative venture, whether you're talking about content provider, someone else driving the process, the developer, the platform operator. There are lots of different people giving contributions to the project overall. It's not always clear who owns the IP. There are wrinkles, particularly when it comes to bringing in freelance operators to provide a bit of input. The default position in the law is the freelancer owns what they produce. So if you're looking to make sure that you've acquired all the rights, you need to make sure the contracts stack up to reverse that position. And there are various different ways that can be done. It can be done by outright acquisition, but typically it's done by a form of licensing, particularly when you're talking about content, and that's a right to use the content. And that right will have parameters on it. So it might have a duration in terms of time, it might have a geographical scope, it might have a particular purpose. But again, all of these things need to match up with what your ultimate plan is for the app. And so having a clear understanding of what the app is intended to achieve and how it's going to be used will drive what kind of rights you need to make sure you acquire so that you get the right consents and waivers. And just in relation to this process, should say this is, it's important of itself to make sure that you can access the platform and comply with all the rules, and also to protect you from liability. But also if you're looking towards attracting investment, or if this is a route towards building a valuable asset that will attract a purchaser either for the asset itself or for your business, then having all these things lined up will help in any due diligence process, because any potential investor or purchaser is going to want to know that all the ducks are in a row, all these boxes have been ticked, and that there's no kind of hidden risk floating about. This has been mentioned before, but there are various different platforms, and there are different structures in terms of controls and legal controls there. The control freak bit under Apple, I'd just like to point out, is a direct quote from someone else. I'm not liable. But, you know, there is a contrast. There is a strict pre-approval process, and the contractual arrangements that back up the App Store are quite different and much more controlling and front-loaded. Having said that, you know, the Android platform arrangement also allows them similarly to pull things from the store if they're not happy with what's going on. So that's sitting there, but there is that contrast. And there are various other routes, but you know, the Android platform and the Apple platform are the big ones. And if you're going to go through a different route, you've got to really have a compelling reason as to why you would invest in doing that. I mentioned engagement, and the kind of key contractual relationships are the kind of distribution arrangement between with the platform operator, so Apple or Google through Android, and the development agreement between the developer and the client, if it's unless it's a kind of self-developed arrangement. The purpose of any contract is to make clear who's meant to do what and when, and to allocate risk. And so, really, the key message, I guess, is to understand what those risks are and make sure the balance is right and fair, because you can sign up to a standard contract and find that what you expected the risk balance to be is actually different. And so things like ownership of IP is pretty critical as well. But really, this is about balancing risk and liability. So how do you manage those risks? Well, lots of different aspects. There's the original concept. There's the question of clearance for rights, relationship with a developer, a distributor, or platform operator, and relationship with a consumer. In terms of concept, because copyright is so soft, doing what you can to record the development and the process of development and who developed what is really important, as is making sure you've got a clear understanding of what all the different rights are, who owns them, and where do you need to get permissions from other people to use the content that you have. Making sure you've got whatever formal contracts you need in place, and understanding what the rules of the platform are. And if you're not sure about them, get guidance. And monitor that there's kind of ongoing compliance, not just one shot. And finally, make sure when you're dealing with consumers that the whole issue of, you know, how the payment process works and the question of privacy and data is clearly delineated, because that's very topical just now, and there is a lot of debate at the moment. You look at the debate that's happening in relation to the new rules on cookies, for example. The whole principles of that debate are very relevant for apps as well. The whole question of how much do you need to ask someone in order to use their data, and if you come up with a novel way to use the information you've gathered from someone, are you allowed to do that? There might be a compelling business case for you, but there might be an issue of privacy for the individual. So what happened to our footballer? Well, we were acting for the guy with the money in the bottom left, so we asked a lot of fairly standard but what proved to be slightly awkward questions, and it turned out that the guy with the idea didn't actually have the rights he thought he had. He had a kind of understanding. He had a bit of paper, but if you scratched the bit of paper too hard, the content wasn't there. So he didn't actually have the rights. And in the absence of the rights, the investor wasn't willing to invest, and the ultimate pot of money wasn't accessible in the way that had been expected. So I think it's really just, from a legal perspective, it's about understanding what the risks are and doing what you can to manage those risks. Make sure that you understand what the rules are and comply with the rules. And I think that's me. Thank you.